Yes. Hello everybody, my name is Martin Ramstedt. I'm going to present an outline of my course, Law and Anthropology, that I teach here at the International Institute for the Sociology of Law in Oñati. Now, why Law and Anthropology in a Sociology of Law program? There are, first of all, more general reasons. For instance, anthropologists and sociologists lay claim to the same founding fathers, like Emil Durkheim, Herbert Spencer, or Max Weber. Then, under the condition of globalization, the distinction between urban and rural communities has become blurred. And so, anthropologists and sociologists nowadays engage very similar research questions in the very same social fields, say. But more specifically, a number of global trends have boosted the emergence of law and anthropology in the wider academic field of law and society. For instance, the cultural turn in law due to global migration, the increasing juridification of the life world, as Jürgen Habermas has put it, the increasing transplantation of legal concepts, norms, and institutions in the context of accelerated globalization, the increasing accommodation of religious and ethnic normativities, norms and practices in the laws of the land, and the increasing convergence of the human rights and indigenous rights discourses. Now, throughout the course, the following general notions vis-à-vis law, on legal practice will be introduced. First, law plays an important role in individual and collective identity formation. Disputes are diagnostic events. They constitute important openings into the social, cultural, political, and economic fabric of a given society. Law coexists, thrives on, and conflicts with the norms of other semi-autonomous social fields, like business world, like the family, like religion or custom, and so forth. Law is not only black letter law, but comes with a certain culture. Now, culture can be broken down into, can be understood in terms of cosmology, aesthetics, performativity, and institutional frameworks. The notion of law as state law can be contested. Non-state normative orders may also be called law, given the family resemblance between them and state law. Now, as to the general structure of the course, in the first week our attention is mainly focused on conceptual issues like the changing notion and role of law in the globalized world of today. What constitutes a dispute, conflict resolution, or justice is always culturally inflected. Legal versus normative pluralism and its corollary, interlegality, will be addressed. Then, juridification as a motor of legal pluralism, which in turn is accelerated by the entitlement discourses and right claims of the different social movements we have witnessed and are witnessing in the world. In the second week, we zoom in on more concrete empirical issues, like the transformation of tradition in the transnational indigenous rights movement. And here we make particular reference to the ILO Convention number 169 from 1989 and the UN Declaration on the Rights of the Indigenous Peoples from 2007. Then, the accommodation of religion by the law of the land. And here we stress the point that freedom of religion hinges on the respective legal definition of religion, which is also always culturally inflected. The ethnography of legal implementation processes in the context of development aid, where we are confronted with a particular kind of legal transparence called project law. Then we pay attention to the vernacularization of processes of vernacularization of human rights and the tensions between human rights and the interventions of the Bretton Woods institutions, particularly the World Bank. Now, as to my approach to teaching. The choice of reading and additional material entails explicit attention to the background of the respective authors and their positioning in a particular field of academic discourse. Contemporary issues are always presented in a historical as well as a comparative perspective. The readings are presented in conjunction with reference to certain points of attention and in relation with specific questions. In class, lively and to-the-point engagement in the discussions is seen as partial fulfillment to credit, and it is approximately 20% are accounted for by participation in discussions, and then the essay will account for 80% of the final grade. And coming on time will be positively reflected in the final grade. I think that's all for the moment. Thank you very much.